Hi, I'm Catherine Ballantyne, a partner at Madgwicks Lawyers. This case update involves insolvency law, and more particularly, the first meeting of creditors for an administration. This is usually seen as a fairly procedural meeting, but as you'll see by below, it's actually quite important. So this case is Blue Chain number 2, 2021, VSC 260, so in the Victorian Supreme Court. In this case, originally the court had appointed provisional liquidators over the company. It then, by consent, appointed those provisional liquidators to be administrators. And the purpose of this was for a deed of company arrangement to be entered into or to be proposed and voted upon by the creditors. A deed of company arrangement is also known as a DOCA, D-O-C-A, and is essentially where the directors or shareholders of the company propose something to the creditors, propose to make a payment to the creditors, say 20 cents in the dollar of their debts, and all the debts against the company are extinguished, and the company gets to essentially start afresh, and it's returned to the directors. In this case, the shareholders who were going to propose the DOCA, or the shareholder that was going to propose the DOCA, wanted to appoint an alternative administrator and wanted that voted on at the first meeting of creditors. The current administrators adjourned the first meeting of creditors without this vote because they felt that this went against what the court orders were and what the court wanted. The matter ultimately came before the court and everyone had a view. So the shareholders wanted the current administrators to be replaced by the court, or if they weren't replaced, they wanted a meeting of creditors where the creditors could vote on the replacement of the administrators. The director saw orders that an orderly administration continue without further attempts to replace the administrators, or alternatively, that the company just be put straight into liquidation. The administrators, the current administrators, sought, amongst other orders, that no creditor may vote on their replacement. Now, the court had to take in quite a lot into consideration. In order for a vote of the creditors to go through to replace the administrator, there had to be a majority of creditors in number and a majority of creditors in value pass the vote. In this case, the court accepted that to remove the administrator, the majority in number would be achieved without related party votes, but not the majority in value. It would require related party votes for the administrators to be replaced. Notwithstanding this, the court felt that it was important that creditors have an opportunity to make the decision for themselves and to vote upon it. So basically, the court ordered that the first meeting of creditors be held in the normal fashion, and that since there was an alternative administrator proposed, that the creditors have an opportunity to vote upon this. So the lesson out of this one is that the court in the insolvency process is very reluctant to get involved and make decisions on behalf of the creditors that they should be entitled to vote for themselves. This is even the case with the first meeting of creditors. As we know, the second meeting of creditors is usually where a lot happens. But even in the first meeting of creditors, the court wants the process to go through and the creditors have an opportunity to decide for themselves. I hope this has been helpful. Thank you.